Our liberties we prize, and our rights we will maintain. This is Iowa Civil Rights History Podcast, where we tell stories about the contribution Iowans and the state of Iowa has made to advance the civil rights movement. Past stories are being told, present actions will be highlighted, and preparation for the future will be discussed. Here is your host, Erick Nganyange.
Welcome to the Iowa Civil Rights History Podcast. In 1868, Iowa became the first state in the nation to desegregate its public schools on the case called Clark versus Board of School Directors. My guest today is Lovell. Ross is an expert of the Clark versus Board of Directors case, and he's here to give us a little bit of history of that case and why that case was so important, not just to the state of Iowa, but also to the nation. So Ross, welcome to the show. And the first question that I want to ask you, when did you get involved with the NAACP? Because you've been a volunteer with them for what, 45 years now?
48 years.
48 years.
I had many African-American clients in Indianapolis where my office was. In fact, I was in the Madam C.J. Walker building, which was right in the heart of the Black community there. And one of the cases that I took on was Bailey versus DeBard. And it was a case that challenged the exclusion of African-Americans from being state troopers in Indiana. And so brought that case in federal court. And after a 4-week trial, we were able to get a consent decree injunction that transformed the Indiana State Police. And I represented the NAACP throughout that litigation and have been involved with the NAACP ever since then. That was started in 1974.
When did you get interested in this case?
I became really interested in the case during the last 15 years. I was aware of the case before that, but as I mentioned, for reasons that somewhat complex, constitutional law during my lifetime largely focused on federal constitutional law. I think that reflected the reality that individual rights claims got reinvigorated by Brown versus Board of Education in 1954 in the Warren Court. And so for about 50 years, why the federal courts took the lead on individual rights constitutional claims. But as those courts have gotten more and more conservative, why the interest in state constitutional law has really grown. And so that's probably consistent with my following it emerging about 15 years ago.
What fascinated you about the case when you read it for the first time?
Well, I knew of the decision. I knew that it preceded Brown by almost a century. The breadth of the arguments being made, the power of the arguments, because it truly has a very powerful, inclusive vision for America and for Iowa. And then you began to realize, well, wow, this was way ahead of its time. And not only was it way ahead of its time, the court did not regress when Plessy versus Ferguson came down in 1896. Chester Cole was the justice on the Iowa Supreme Court. He eventually became Chief Justice, who wrote the opinion in the case. But another reason I became keenly interested in the case was that Chester Cole, justice on the Iowa Supreme Court, was the founder of the Drake University Law School back a few years after this case came down. And so, hey, that's a great treasure for Drake to have. And as you know, undoubtedly, why lots of other institutions and law schools around the country are taking the names of some of their founders off of the walls and off of buildings because they were on the wrong side of these civil rights and slavery issues. So there's reasons for Drake to be really proud of this. But he wrote, and this is a quote, "The policy of the government to organize into one harmonious people with a common country and stimulated with the common purpose to perpetuate and spread our free institutions for the development, elevation, and happiness of mankind," end quote. That's what he reflected as the equality values of Iowa. And then he went on to say, were we as a court to uphold the power of the Muscatine School Board to segregate students on the basis of race, Our ruling would, quote, sanction a plain violation of the spirit of our laws. And he predicted that racial segregation, quote, would tend to perpetuate the national differences of our people and stimulate a constant strife, if not a war of the races. Wow, end quote. I mean, that's pretty powerful stuff. It's a really powerful vision of equality that the Iowa Supreme Court adopted with Chester Cole as its leader in 1868, 86 years before Brown versus Board of Education, almost an entire century.
About 9 of you guys was it 2018? You wrote this 150 years reflection of Clark versus Board of School Directors. And you wrote the introduction, about 25 pages of that. Why was the need to put that piece together?
Well, it was a story that I, in particular, thought really needed to be told. I thought most lawyers, most people in Iowa did not know the story. I was particularly keenly interested that it be told because the two leading advocates in the story have ties to both the University of Iowa College of Law and to the Drake University Law Schools, and I think that both can be really proud. And I think that the nation as a whole doesn't know this story, unfortunately. Maybe a number of reasons. I think part of it's just kind of that we're in flyover country. Iowans are understated. We're relatively modest. We don't toot our own horn that much. And so it seemed to me like that's a story that needed to be told. And 2018 was the 150th anniversary of the decision. I proposed to Drake. I was retired at this time. Proposed to Drake. I proposed to the University of Iowa. I proposed to the Iowa Supreme Court. And the Iowa Supreme Court was really enthusiastic right from the outset. Chief Justice Mark Cady, he could see the importance of it. He called it a defining moment for the Iowa Supreme Court. And then I was pleased that Drake got on board and Iowa finally got on board. They were changing deans at the time, and so that slowed their getting involved. But we had a symposium. We had a major rededication of the building on the Drake campus that's named for Chester Cole. It was the first law school building on the campus dedicated in 1902, and so we rededicated that. We've had a group of scholars that we've referred to as the public service scholars, but we've renamed that so that they are the Chester Cole Public Service Scholars. And then there was a huge banquet, I think, for probably at least 500 people that honored the Iowa Supreme Court. The Governor Reynolds, dedicated it.
One of the things in there you mentioned that you say Iowa was the first court in the nation to rule segregation of public schools unlawful. It was only 19th century court to hold school segregation unconstitutional.
That is true.
So Iowa was the first court in the nation?
The first court in the nation to do so.
Wow.
There were two other courts in the 19th century that also held that segregation was a violation of their state statute, but the Iowa Supreme Court was the only one that said it was the violation of the Iowa Constitution's Equality Clause, so that the legislature could not go back on that. And so that made it really important. And,
what was the other two?
Oh, I think Michigan was one, and the other one I don't remember right now. I think Kansas. I think Kansas and Michigan were the two. Okay. Some of the states that you think of as our more progressive states, upheld segregation. The Massachusetts Supreme Court and the Roberts versus City of Boston upheld segregation. The New York Court of Appeals upheld segregation. The California Supreme Court upheld segregation. So the Iowa Supreme Court had the courage to be the trailblazer, the leader, and they stuck by their guns. So you've got to give them a lot of credit.
Oh, wow. And it was the only 19th century court to hold school segregation unconstitutional.
Well, right, and
That's
probably
crazy.
they were the only one to hold it unconstitutional anywhere in America until probably I think maybe the California court a few years before versus Brown finally changed their position after the Plessy versus Ferguson case came down from the United States Supreme Court in 1896 that said that, hey, equality can be segregation, if separate but equal. Why, obviously most courts followed the U.S. Supreme Court lead on that, but the Iowa Supreme Court never reversed the Clark case. And this is important because the Clark decision was decided based upon the equality clause of the Iowa Constitution. The Equal Protection Clause of the federal Constitution, the 14th Amendment, had not been ratified yet. It was a few months later in 1868, but it had not been ratified yet. So their sole basis for their decision was the Iowa Constitution Equality Clause. And that's important then because, as we've talked, I mentioned this, the state courts, must follow the federal constitutional decision, but it sets a floor.
Yeah.
It sets the minimum standard of individual rights. It does not set the ceiling. And so a state Supreme Court, using the independent authority they have under their own constitutional rights provisions of their Constitution, they can do better. And we've seen that here in Iowa since the year 2000. The Iowa Supreme Court has invoked various clauses of the Iowa Constitution to provide greater protections than the U.S. Supreme Court had accorded people across the nation pursuant to the federal constitutional provisions. Probably the most notable one that most Iowans would be familiar with was the case of Varnum versus Breen in 2009, where the court held that a right to marriage equality on behalf of gays, that was at least 6 or 7 years before the U.S. Supreme Court followed and reached that same decision, I think about 2015 or 2016. A case that's not quite as well known, but it's one that I mentioned David Walker and I, we worked on the case. We wrote an amicus brief for the NAACP in a case called State versus Lilly. And in that case, the Iowa Supreme Court embraced our suggestion that it use its independent authority under the jury trial right, the fair cross-section requirement, and thereby it helps make sure that our juries are racially representative of their communities. And so they set a more protective standard under the Iowa Constitution than the U.S. Supreme Court had fashioned under the federal Constitution in State versus Lilly in 2019.
Who you think did more to advance the civil rights in Iowa, the court or the legislature?
Well, I think they work hand in hand. I mean, I think that certainly the court took the major steps. The 1857 state constitutional convention created that equality clause that they relied upon in Clark versus Muscatine. They took steps to end many of the racially discriminatory, racially exclusionary provisions that had existed in the legislation. And then eventually in 1868, a few months later, in November, it was on the ballot, and the Iowa citizenry, provided Black men the right to vote. And I should add that I mentioned that Chester Cole, the author of the opinion in Clark, was a dedicated civil rights advocate for many years. And he, as early as 1865, following the Civil War, was one of the very first people in public life to come out in support of saying, look, he bought into the argument that actually Alexander Clark and Frederick Douglass were making, that, hey, if Black men can carry a musket, if they can fight for freedom in the Civil War for the Union Army, by golly, they ought to be able to vote as well. So the Iowa citizenry responded to that favorably and granted Black men the right to vote in Iowa in 1868.
I want to go back to the doctrine of separate but equal before we get to this case, because that has a lot to do with the case of Clark versus Board of School Directors. You, as a Constitution person, explain what that doctrine means and why did they think it was important?
Well, I think the doctrine arose initially in a case out of the Massachusetts, the Boston case in 1850, and I think that when they said equal, they said it was not unreasonable for whites to prefer to go to school with whites, and that as long as we provided black children schooling and they could go to school there, that was equal. That they were not being excluded from education, but it would be just separate. And indeed, in Iowa, about 11 years of Iowa as a state, from 1846 to 1857, black children were totally excluded from the public education. And one of the key provisions in the 1857 state constitution was that a free public education would be made available to all youth in Iowa. And there was a motion to change that, to exclude black for only white, in other words, to allow only white children to get the free public education, and that was defeated. And so that was an important step forward. But the legislature, or the Constitutional Convention, did not really address the issue of whether it could be a separate education. And so that's what arose then in the Clark case, because the Muscatine School Board, the local school board, imposed a racial segregation policy on its school system.
So the idea of separation but equal is that you can separate the student based on color, but their education needs to be exactly the same, and their facilities need to be the same. Is that what it is?
I think that the cases always never said that it had to be exactly the same. And as you can imagine, with all white courts, making the decisions, why it was easy for them to view that as reasonably the same or reasonably comparable would be, or at least adequate. I think that's probably what the way instead. And so that was one of the fights, was between, is it equal or is it merely adequate?
Now, I want to get to the case, man. So the Clark versus Board of the School Directors of Muscatine, one of the biggest cases in the country that happened right here in Iowa. Alexander Clark, he came to Iowa in 1842. 1848, he's getting married. His first kid was born in 1849. Rebecca, 1851. The second one, 1852. The third one, the second and the third one passed away. 1854, Susan Clark is born. And you mentioned this a little bit, and I'm not going to get to the Alexander Clark Jr. 1854, Susan is born. 1857, Iowa Constitution. Was Alexander Clark waiting at all these years to make that move?
Oh no, he was not waiting at all. He was a giant in civil rights. I think for most of his life in Iowa. I mean, he was very active in the Underground Railroad. Helping slaves who were escaping from Missouri as they would come up along the Mississippi or through Muscatine. He was very active in those efforts. He was very active in opposing the racially exclusionary laws in Iowa. He was very active in that 1857 Constitutional Convention. One of the things that he got there was, in addition to the provisions of the Constitution that did get changed, they put it on the ballot that black men could vote for the first time. And that was on the ballot in 1858, but it was defeated badly. The vote was something like 48,000 against and 8,000 for. I mean, it was not even close. And I think that there's a lot of reasons, but I think a lot of that was that even a state like Iowa that considered itself progressive, because blacks had been enslaved, except for a very small number of free blacks, they not only were they enslaved, but they were denied any type of education. They were all illiterate, except for, again, a minuscule number. It was a criminal violation if you tried to learn to read or write if you were black. So I think most whites could not, even those who were against slavery, really couldn't conceive of blacks as equal.
Yeah.
And so I think that's what that vote reflects. But when the Civil War broke out, Alexander Clark, he was a friend, and he had corresponded with Frederick Douglass, the great African American civil rights leader of that time, and they recognized that if you want to make a claim for freedom and equality, you've got to be prepared to make the biggest sacrifices that a citizen can make, and serving in the military is probably about as big a sacrifice as there is. And so Clark went out and recruited something like 1,100 African Americans in Iowa and Missouri to join the Union Army. And he enlisted himself at the age of 37, and then eventually was disqualified because of pre-existing ankle injuries. But he had a huge impact, on that. And then after the Civil War, it was he who led the charge to again say, "Hey, I know we got turned down in 1858 for the right to vote, but things are different now. We had 1,100 black men who fought for the Union cause and gave their lives, and they fought with the courage and exemplary poise, and proved that if we can handle a musket, we certainly ought to be able to vote." And so the legislature put it back on the ballot, and in 1868, just a few months after the Supreme Court made the decision in Clark itself, another huge civil rights victory, and that was that black men in Iowa were allowed the right to vote.
Most of the civil rights cases in 19th century is usually the plaintiff lose the case from a district court. But this case was different because Alexander Clark actually won the case.
Right. No,
in Muscatine district.
Well, I think that, he had considerable success as a business person he went from being a barber to being a business person because he made very good investments. He was very hardworking. He obviously was a brilliant person.
Absolutely.
Even though he was largely self-taught in terms of education. I think he had a lot of support within the community because of the leadership. He was a leader in that community, which was obviously extraordinary for an African-American man in that era, even in 1867. I don't think we've mentioned, Eric, but public television, has a documentary that came out, I don't know, 5-6 years ago, maybe longer than that, on Alexander Clark, Lost in History. It's a 30-minute documentary. It is really wonderful in terms of telling his story. They spend, probably 4 or 5 minutes on this case, but they talk about all of the rest of his life, and it's a fabulous story.
Yeah, I watch, and I recommend people to take a look at it. So in 1867, he wrote a letter to the Muscatine Journal, the Muscatine newspaper, expressing his concerns. Why did he decide to write a letter to the newspaper instead of just go straight to the court like he did?
Well, I think that, it's in law, there's a principle that ordinarily you would try to exhaust all of your other remedies before you file a lawsuit, because filing a lawsuit, it's a big deal.
Yeah.
It's stressful, it's expensive. And so there's a lot of reasons to try to resolve things before that level. And I think he probably thought that he might have a chance to persuade the school board because of his position and what a wonderful citizen he had been, and his family as a contributor, a taxpayer in the community. So those would all be reasons. I think also, even though he had been very successful, there's still, I'm sure, lots of people in Muscatine and in Iowa who were still very much opposed to African Americans, or at least wanted to keep them in their place, that sort of thing. Mm-hmm. And I can imagine that, certainly all of our experience and even contemporary 20th century, blacks who filed lawsuits or spoke out, they often experienced severe retaliation, both in terms of, their jobs or other types of things. And indeed, nobody knows for sure, but sometime after the case was won in the Supreme Court, Alexander Clark's home was burned down. And the investigation indicated it was arson. No one ever was convicted or ever charged. But one can imagine that may well have been a retaliation for his outspoken leadership in terms of African American rights, including in this very case. But he was able to get lawyers to represent his daughter. The law firm of Richmond and Carskadden represented them in the case. And then, interestingly enough, the Attorney General for Iowa, Henry O'Connor, lived in Muscatine, and at this time, the Republican Party, was the political party that was most supportive of African American freedom and equality. And so O'Connor, not with his Attorney General cap, but just as a private lawyer, also was involved in the representation of Susan Clark and her father in this litigation. And so you're right that in this case, the trial court, the district court, that involved, I think the judge was the brother of the Richmond law firm, did come down and rule in favor of Susan Clark on her equality claim, which that was remarkable that the judge would take that stand. Yes.
Was Susan residing around the Grammar Number 2 school?
Well, she was a mile away. There were other elementary schools that were closer, but that was the only school that was designated for African Americans. So she had to walk a mile further than she would have if she would have gone to the neighborhood school. But the principal argument that she made wasn't that the neighborhood school was closer or more convenient. It was that the black school failed to really do education in the area of grammar, and that as a result, no black child had ever qualified for high school, had never passed the exam. Clark argued that the difference in the teaching quality and not having that available to teach grammar was holding black children behind, including his daughter.
On September 10th, 1867, Alexander Clark and his wife sent Susan Clark to that grammar school number 2. School refused to admit Susan, under the ground that basically she was black.
The school board did not try to say she wasn't qualified. They were very clear that they had a racial exclusion policy. There was no doubt that she was African American, and so they applied that policy, and they argued that it's a reasonable policy. We make a lot of other classifications. This is the wishes of the white parents in our school district to keep it exclusionary, and we think that that case out of Massachusetts, that Roberts case, is authority for what we're doing.
On the behalf of Susan, Clark sued the board on October 3rd, 1867. District Court in Muscatine agreed with Alexander Clark. Then the board appealed to the Iowa Supreme Court. Do we know how many cases in Iowa, like the civil rights cases, that the plaintiff actually won on a district level and the defendant had to appeal? Because we don't hear a lot of these cases even across the country in the 19th century.
Well, I don't think we know for sure, but there just were very few cases. You have to realize that Iowa is still a very sparsely populated state and very few numbers of African Americans. At this time, there would have been no African Americans attorneys in Iowa. There probably weren't that many white attorneys that would take such cases if they did. And until the Clark case came down, there really wasn't very much in the way of favorable precedents for them to work with. But after it did come down, why there were a small number of cases that made their way to the Iowa Supreme Court, and they issued some very progressive additional rulings, one on gender equality, the Arabella Mansfield matter, and then also in 1872 in the Coger versus the Northwest Union Packet, they issued a unanimous, really progressive public accommodations case that again led the nation for about 100 years on behalf of African Americans. And then in 1875, there were two cases out of Keokuk, Iowa, the Dove case and the Smith case. And Keokuk was, right on the Mississippi River and right adjacent to Missouri, and so it had the largest black population in 1875. The Keokuk district said, "Well, hey, because by 1875, of course, the Clark decision had come down, so segregation was unlawful, unconstitutional in Iowa." But it turned out the black children in both of those cases were excluded from the school in Keokuk, they were excluded from the white school at Keokuk. Well, Keokuk denied it and said, "Oh no, we just didn't have any seats available. There were no seats available in the school that we wanted to go to." And so, to the credit of the attorneys there, why they put on evidence that showed, "Oh no, not so fast. You admitted another 8 or 10 students after you turned the black students down in these instances." And so that went back up to the Iowa Supreme Court. And, this was important because, it's now 1875 and, Reconstruction has been going on. But we also know that, hey, too many whites are getting tired of Reconstruction and the effort it's taking. There's a political backlash. President Grant was a big supporter of it, but he's been experiencing backlash. But to the credit of the Iowa Supreme Court, they said that the principle in the Clark case is not just a principle of against a formal policy. Now, remember, the Muscatine School Board acknowledged that, hey, we're excluding Susan Clark solely because she's black. That's why we're excluding her. Well, in the Keokuk cases, they said, "Oh no, we don't exclude anybody because of race. There just wasn't any seats available." And so the Iowa Supreme Court, again, not only held its ground, but they expanded the principle to say that, hey, segregation, whether it's overt, as in Clark, or whether it's covert, is unconstitutional under the Equality Clause of the Iowa Constitution. And so, again, they not only didn't back down, but they continued to expand the scope of that right in the Dove and the Smith cases in 1875.
The decision was 3-1. Justice George Wright was the dissenter. His whole idea was the board had the discretion to decide how the kids need to be, which school they need to go to. So he did not think there was anything wrong with the decision. Help me to understand.
Yeah. Well, first of all, you need to understand that he and the other 3 justices all were big supporters of the Union Army and the Civil War. So they were in support of that, and I think supported freeing the slaves and emancipation and so forth. So he was not. It's clear that he was no racist or anything like that. Okay. Mm-hmm. I think that when you if you read the dissent, what you see is that him saying that, the school board eventually came back and said, "Hey, we will provide a teacher to teach grammar at the black school." Because remember, that was one of the complaints that Alexander Clark had made in his letter to the Muscatine Journal, was that they're not teaching grammar and our kids can't get into high school without that. In George Wright's dissent, he thought that, separate but equal, as long as, he didn't use the word exactly equal, but as long as it was respectively equal, I guess might be what you might say. And so if they were to offer and actually fulfill that, to provide the teaching of grammar at the black school, I think he thought that was constitutional, then enough equality. So he bought kind of the separate but equal, if it in fact was reasonably equal. As we know, separate but equal, even 100 years later, was almost never even remotely equal. So I think you have to look at his situation as, in the big scheme of things over all those years, certainly not racist, at least not in the way that we saw that the separate but equal was used by the Southern schools for so many years following Brown versus Board of Education.
Then on April 14, 1868, the Iowa Supreme Court handed the decision that changed the state forever and changed the country forever, desegregated all public schools.
Well, hallelujah. It was a great decision. I think that, I don't know that you could say it changed the country at that point. It had that potential. And I think that, one of the themes that we used in our sesquicentennial celebration of the Clark decision was a quote from Ulysses Grant, who was then the Republican presidential candidate from our neighboring state of Illinois. There was actually a book that referred to a quotation of him referring to Iowa, the bright radical star of equality. And wow, isn't that an image? In fact, we put it on a T-shirt. We went down to Ray Gun and working with Mike Draper. That was the T-shirt we used for our sesquicentennial celebration of the Clark case. Shine on, you bright radical star. And I think he was also projecting. He was confident that Iowa, that bright radical star, would vote favorably. I'm sure probably for himself, but also would vote favorably on that pending constitutional amendment to allow black men to be able to vote. And that, of course, is exactly what they did. And you look at the difference. Remember, I told you when the vote was taken on the 10 years earlier in 1858, it went down by about a 6-1 margin. I think it was 48,000 to 8,000. It was just overwhelmingly defeated. So what's the difference in 10 years? Well, I think the difference in 10 years is the Civil War.
Yeah.
And also the performance, the courage of those black soldiers who, at the end of the war, there were 200,000 African American soldiers fighting for the Union Army, and they helped turn the tide. So I think that as whites began to realize, well, wow, we had no idea that they had these capabilities and potential. And they did fight, and they fought courageously, and many gave their lives. And so I think that's what our Alexander Clark and Frederick Douglass recruited black men into the Army, was that, hey, this can change. Things can change if whites can be educated about your potential and see you fight for the right cause and show the courage and the skills that we know you can provide.
Then 1871, Susan Clark graduated from that school, and she became the first black graduate of the public school in Iowa.
She was, and she obviously did well because she was one of the chosen speakers at the commencement. She gave a talk there that was reported on in the Muscatine Journal.
Wow. Interesting with the Alexander Clark kids. Susan was the first one in Muscatine, and Alexander Clark Jr. was the first one in Iowa Law School and University of Iowa.
They were pathbreakers. I think without a doubt that, their parents were very, very intelligent and hardworking and industrious, and those kids followed the same way. I mean, we know more, and again, this just reflects, I think, the gender roles of the time and so on. We know more about Alexander Clark Sr. and Alexander Clark Jr. than we do about the two Clark sisters, Rebecca and Susan.
You say Susan Clark did not experience threats and abuse like other kids in the late 50s and 60s after the Brown versus Board of Education. So she did not go through that stuff in Muscatine?
Well, there's nothing in the, you have to realize the reporting was pretty, there's not that much history, but we're not aware of any. I can't imagine that she might experience some ostracism. I mean, if the parents were all dead set against any black child being admitted, you can imagine that she experienced some ostracism. But there was certainly nothing in the record that we could find, and I think a lot of people looked at it to see that any of the kind of taunting or physical abuse or threats that you saw in the Deep South, and not just the Deep South. You saw it in Boston, for heaven's sakes, in the 1960s and 1970s when desegregation occurred there.
And in the same pieces, you say all the 4 justices on this case were Republicans. You think their political views played a role on how they decide in the court?
Judges are human beings, and courts are human institutions, and so I think that without a doubt, why your backgrounds and views can influence how you interpret equality. I read that language from Chester Cole's opinion that he could understand how separate segregation, was a denigrating, a subordinating thing in the reality of the world, and so that was important. The lots of other people, including people that would not want to call themselves racist, didn't seem to quite understand how that could have that kind of subordinating, denigrating perception, and so his view was way ahead of its time. And I think that, I was struck by some research that David Walker did for that symposium. And, he found, Cole initially grew up in New York State, and then after being licensed as a lawyer, practiced in the state of Kentucky, a border state that had segregation.
Yeah.
And we don't know the details of this, but there was one case that he represented a black mother and her children who claimed that they were free, and they brought a freedom suit. Well, I'm sure that I'd be totally amazed if they were able to pay him for the representation. I would assume he did that pro bono, and despite putting on the case in the trial court, he lost in the trial court. And I would imagine lots of people say, well, that's good enough. I can't afford to keep doing this without any compensation. But he went on and took the case to the Kentucky Court of Appeals, and there he won that case. And so, he had a record, of sticking out, in a slave state for African American freedom and equality way back before he even got to Iowa. And so, yes, I think those human experiences make a significant difference in how judges construe language in constitutions or even in statutes, oftentimes. And so, yes, I think that their background makes a difference. And certainly, the Republican Party, by far the biggest supporter for racial justice and equality.
86 years later, 1954, finally, the U.S. Supreme Court got caught up to something that Iowa's already done, almost like you said, almost a century ago. Do you know if the U.S. Supreme Court used Iowa case reaching their decision or Iowa experience to say, hey, you worked on this state for 86 years?
It's really disappointing that the Chief Justice Earl Warren, in his opinion, did not cite the Clark case. And I don't know how that is. I suspect it reflects just that they didn't have computerized legal research or whatnot, or it just got buried. There were so many different briefs that were filed, but it's a shame. It really is. I think had the case it'd been great for him to say, hey, there was a state that showed us the way 86 years ago. It's time for us to take this step, and even quoted some of the language I read about, how important, we need to be a harmonious people, to pull together, and that if we continue to subordinate people on the basis of race, that it'll undercut the fabric of our country and even maybe lead to a war of the races. It's just too bad that some of that couldn't have been quoted or put in the opinion. And it also would have been good for Iowa people to say, hey, wow, I had no idea the Iowa Supreme Court had the courage to take that stance. But it was also really important that the Iowa Supreme Court did not back down when Plessy versus Ferguson came down in 1896 and said, hey, segregation is just fine. It's constitutional. That's enough. It would have been, most states acquiesced in that view, and followed that. Iowa, to its credit, did not.
Now, I'm assuming Clark did not care more about the integration of his kids to the white school versus how much he cared about the better education. If there was a black school right there in his neighborhood with better education, he wouldn't mind to send his kids there. It was not about the integration.
I don't know the answer to that question. That was always a really difficult question for civil rights and African Americans. I thought that W.E.B. Du Bois, the great African American intellectual and one of the founders of the NAACP in 1909, captured it really well. And this is just a general quote, but the quote was pretty much like, that in terms of the choice between a mixed school, which was how the integrated school was referred to, or a separate school, his comments were that the mixed school would be better because it would reflect society and the experience, as long as the teachers understand the culture of Black students, as long as the teachers are welcoming, as long as the teachers in the facilities are good. That would be the ideal. But if Black kids are going to go to a school, a mixed school, where the teachers are hostile or indifferent to them, and the students likewise are not welcoming, we'd be better off in a separate school. And so, that's not an easy choice to make. I mean, children, whether they're white or Black, are fragile, and we know now that there's been studies that have shown that many of the Black children that went to so-called integrated, that did the integration but were faced with hostility, they have PTSD. They had PTSD for the rest of their lives, from the trauma that they went through, and so the white supremacy and the white racism is such a terribly sad chapter of American life. And so I think to say integration or separate, there's not an easy answer to that.
This is a 150-year-old case. Why should folks of Iowa care?
Well, they should care because we have a tradition, of being a leader on equality, on racial equality and gender equality, and that's something that we should continue to lead the way on. And then also, as I mentioned, the case was decided under the Equality Clause of the Iowa Constitution. That gives our courts some additional authority to lead the way, to provide for greater protections on individual rights. And as I mentioned, the Varnum case on gay rights was an example. The Lilly case in terms of jury trial rights for people of color, represented juries is another way. And then another area where the court has utilized that independent authority is in a number of areas of criminal procedure, where they've taken steps to provide persons accused of crime and so on with greater protections than the U.S. Supreme Court has provided them under similar provisions of the Constitution. We like to think of Iowa as a leader and progressive, and we have been at times, and we have the tools and the tradition to do that again.
Good deal. Anything else you want to add on this case, Russ?
The case itself is a landmark. I know that when Dean Anderson, Jerry Anderson of the law school, President Marty Martin of the Drake University, the three of us, we wrote an editorial for the Des Moines Register that was back in January of 2018, announcing that we were going to have this symposium, and we characterized it, the case as one of the great cases in all of American jurisprudence, and really believe that it is of that stature. I mean, it's one that Iowans should know. For those that are listening to the podcast, that would like to learn more, I encourage you to go to the Drake Law School website. If you Google Clark versus Muscatine, Drake Law School, Clark versus Muscatine Schools, or even put in Clark 150, because it was the 150th year, you will get the link will come up, and you'll find a wealth of information that's free to tell you. You'll have the opinions in the case. You'll have all the articles that Erick is referring to that I and others have written. You'll have links to so many other aspects of this decision, this history that Iowans should be proud of. And so I encourage you to do so. Again, I think, the human beings are really important to the story. And Alexander Clark is a giant in civil rights. And so I really, the PBS documentary is on that page 1 of that website. And Chester Cole is a giant in his own right, the author of the opinion and who was the leader on so many aspects of civil rights at that time. And as I said, we're very, very proud that he's the founder of the Drake Law School. Let me, one more thing. The other great tie that Alexander Clark has is to the University of Iowa College of Law. Both his son, Alexander Jr., was the first African-American graduate of the University of Iowa College of Law, and eventually ended up practicing law initially in Chicago, but then moved back to Iowa and practiced in Oskaloosa, Iowa, for his career. And then Alexander Clark, at age, I think, 56, which, back at that time, that was towards the twilight of one's expected life experiences. He went to law school at the University of Iowa College of Law, top 10% of his class, which is really remarkable. He was nominated by President Harrison in 1890 to be the ambassador to Liberia in Africa. Unfortunately, he caught an illness over there, and that's where he died. But he had a wonderful career. So check out that PBS documentary on Alexander Clark. It's a great Iowa story.
Well, Russ, thank you very much for your time.
Well, Erick, thank you for the opportunity. I think it reflected that this is a story that I like to tell over and over, and I just hope that more and more Iowans will learn about it and tell their families and friends, particularly Drake Law School graduates, Iowa College of Law graduates. They should be telling this story, but it's an Iowa story. It's one that, obviously it's a good example of that grassroots advocacy by Alexander Clark. What a grassroots advocate he was, and then eventually became a lawyer. But then you can also see the law reform lawyering that was really important here to get this constitutional ruling, implemented and actually occur.
Thanks, Russ.
Thank you.